Ladies and gentlemen, welcome back to the Indie Zone. My name is Kathy. We will be having a live gavel to gavel event here on the Indie Zone, April 9th, 2025, commencing at 8:45 a.m. Boise time to provide gavel to gavel coverage on these absolutely critical upcoming oral arguments on the state of Idaho and the defense's motions in limine. When you see events associated with motions in limine, you know that trial is fastly approaching. And looking at Judge Stephen Hippler's January 31st order, we can see how quickly these motions in limine will be filed in this case. This was actually an order amending the pretrial and trial order that His Honor entered back in October, where he set multiple matters leading up to the trial in this case, which I continue to assert commences July 30th with the process of voir dire, which is jury selection. This is a jury trial. Mr. Kohberger's case will be brought before a jury of his peers, as he is constitutionally entitled to. He, at all times, is considered innocent under the eyes of the law of the charges that have been brought against him, for which he will stand trial, until or unless that jury adjudicates him guilty in the case in chief, aka the guilt phase of the proceedings, or Mr. Kohberger, conversely, alternatively, decides to plead to the charges, which there's no indication that he will, but that is our constitutional guarantee. Motions in limine have to do with admissible evidence and having certain evidence thrown out of the case. This is why the parties will be in limine before trial, arguing their respective positions that certain evidence should not be presented to the jury. Let's look at Judge Hippler's schedule set forth in the January 31st order. Tells us here that all motions in limine, both sides now, state and defense, shall be filed no later than February 24th, 2025. This modifies the pretrial and trial order where these motions in limine were due February 10th. So as of now, due February 24th, all responses, these are the responses in opposition, filed no later than March 17th, and any replies filed no later than March 24th, 2025. These are the briefings. When you hear the term the briefings, it's motion, response, reply. Somebody files a motion in limine to have a specific record not be able to be introduced into the case. Then you have a response from the other side in opposition, feeling that that record should be admitted into evidence. And then there's a reply from the initiating party, the person who filed the motion, explaining why the other side got it wrong. In other words, replying to the response. When that's filed, that's it. Briefings closed, and then oral argument follows. That's the hearings. In this case, rescheduled. It was for another date. It's been moved. Our date certain as of right now, April 9th, 2025, and if necessary, continuing on to April 10th. Court did exactly what he did with prior motions that were entertained, the motions to suppress. That also has to do with excluding evidence, but on other grounds, on the grounds that it violated Fourth Amendment privileges of Mr. Kohberger. That's the theory. Those motions to suppress are still pending ruling. As soon as the 14 motions to suppress evidence are ruled upon in the form of a written order, we will report to you. But going back to motions in limine and discussing their importance and what they do, let's look at a case that you may have heard about that was also in the area. It was State of Idaho versus Laurie Noreen Vallow, aka Laurie Noreen Daybell. State's motion in limine on mental health evidence and memorandum in support. So we see here two things. We see the motion, application for a court order, with the memorandum of law, where counsel here is going to explain why this motion should be granted. Here, under the argument section, they go into the legal standard. Say here, less than a year ago, and this was filed on January 26, 2023. So they're saying here, less than a year ago, Idaho Supreme Court reiterated, meaning they restated again, quote, a motion seeking a pretrial ruling on the admissibility of evidence is known as a motion in limine. Idaho's courts recognizes the importance of a motion in limine. State versus Young. This is a 2001 Idaho Supreme Court case. So here we see the explanation and the purpose of what this motion in limine is. It has to do with the admissibility or inadmissibility of evidence, and then the standard in Idaho that Idaho courts recognize, they view these motions as being important. Why? A motion in limine enables a judge to make a ruling on evidence without first exposing the jury. It avoids juror bias, sometimes generated by objections to evidence during trial. The court's ruling on the motion enables counsel of both sides to make strategic decisions before trial on the content and order of evidence to be presented. See generally Warren versus Sharp. And this is a 2003 Idaho Supreme Court case, making the notation this was overridden, but on other grounds other than this legal principle. And this is this 2014, this is the Blizzard versus Luttaby case, Idaho Supreme Court, overruled, but on other grounds other than what was just stated here. So we see here that motions in limine deal with evidence at jury trials that one side or the other will try to get excluded from the case on various grounds. That's what will be filed very shortly, responses thereto and replies. And the hearings on the 9th of April is what we will be covering live in our unique way of looking at the case, where we look at the facts. We will be introducing facts and discussing facts from the case during downtimes. We'll be providing you with explanations of what's going on, giving you our opinion. So I hope that you will join us, whatever side of the fence that you're on. If you believe right now, even though we know and we recognize that Mr. Kohberger is cloaked with the presumption of innocence, you may have an opinion that's making you believe that the state will have a hard time proving its case. You may feel contrary. You may feel that there's been sufficient information that's been produced thus far that makes you conclude that the state got it right. Whichever way you're facing, anywhere in between, if you're undecided, if you don't know, if you're just now learning about the case, please join us on the 9th of April. We would love to have you joining us live. We'll have some live chat. And until then, and until our next presentation here on the Indie Zone, thank you for joining us here today.